Absolutely. If I get a notice of hearing, if I get an offer, I get any communication from the other lawyer or the other party, you will get a copy of that right away and then have an opportunity to look at that so that we can discuss it and decide what to do next. Game analogies are kind of tough in a divorce. It's my job to make sure that you understand what a reasonable range of expectations is. What could happen here? What is the judge likely to do on this question from range one end to the other, and then decide how you want to proceed on that. You get to decide what the most important issues are to you, and anytime a suggestion is going to be made by us or an offer is received by us, you will get to make the decision about where to go from then after we discuss it and you understand what your options really are. In some cases where one party has stayed home and taken care of business at home, raised the children, entertained, done all those things because the parties have agreed on that, it's only fair to give that person a chance to start over again. There are other cases where somebody isn't able to make enough money to really support themselves, and it's appropriate there too. It's very rare for spousal support to be a lifetime obligation, and every case is different. What's appropriate is different in terms of the amount and the duration. Judges talk and lawyers talk about legal custody and physical custody. Legal custody is shared decision making. It's where two parents are to talk, discuss important decisions about their children, and generally try to agree on what's best for the child. And where parents are able to do that, studies have shown that that is the best possible world for the children, to see parents working for their benefit, setting aside their differences to put the children first. That's absolutely the best. Physical custody, every case is different and every child is different. Some children do quite well going back and forth. Other children need a more stable base. It's not a one-size-fits-all. Every child is different. You can have kids playing and tell them to get in the car to go to the store, and two of them will hop in the car and one of them has a meltdown because he doesn't want to be interrupted. So all of those things have to be taken into account in crafting a result that's going to work for your family. My retainer fee is based on my guess as to what your case is ultimately going to cost. And it's based on time. So my retainer fee for a case involving minor children starts at $3,500. If there are really complicated issues, or if the family owns businesses, if there are more complicated things involved that are going to take more time and require more expertise, the deposit may be larger. For a case that does not involve minor children, my retainer starts at $2,500, again, and up depending on the individual circumstances of the case. It is, in my office anyway, a deposit, and I bill against that. So at the end of the case, if there are funds left that have not been used, that's your money and it's returned to you. My time is billed out at generally $250 an hour. I have, in some situations, reduced that. There are other cases that are really complicated, have to do with assets in multiple countries, families owning businesses in this state and other states, and if it requires an extra level of expertise, there may be an adjustment for that. I also offer a discount in my written contract when payment is made on my bill when it's sent out every month within 21 days. No, I do not bill the time for my paralegal or my secretary. The time that is billed is for work that I do alone. There may be some costs, filing fees, or other things that you would see coming in, but you will not be billed for time by anybody other than me.